The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state.
A woman facing multiple criminal charges stands before the judge, but instead of going to trial, she agrees to plead no contest to theft and DUI while several other charges are dismissed. The judge carefully explains that this plea will still result in convictions and probation. But here's the big question: when someone agrees to testify against a co-defendant in exchange for reduced charges, is it justice or simply strategy? Under Tennessee Rule of Criminal Procedure 11, a judge must ensure that any plea agreement is voluntary and fully understood before accepting it.
I do.
State your full name for the record.
Jerry Kristen
You can
Bumpus.
put your hand down.
Oh, Jerry Kristen Bumpus.
Ms. Bumpus, you are here today on a multi-count indictment. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges and talked them over with Mr. Vaughn, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter this plea of no contest to 2 of the counts and have the remaining charges dismissed. Do you understand that you have the right to plead not guilty to all charges and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand if we had the trial, you would have the right to have a lawyer and to have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you can be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you? You can bring in your own witnesses by the use of a subpoena.
Yes, sir.
Do you understand that at trial you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that if you enter this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is to approve what your lawyer has worked out with the state.
Yes, sir.
Do you understand that that's going to result in convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
Yes, sir.
One of the charges you're pleading to is driving under the influence of an intoxicant, and I'm required by law to advise you of the following. Any person who is convicted of a first offense driving under the influence shall be fined not less than $350, no more than $1,500, and shall be confined in the county jail or workhouse for not less than 48 hours, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for 1 year, provided that if at the time of the offense the alcohol concentration in such person's blood or breath is 0.20% or more, the minimum jail sentence shall be 7 days instead of 48 hours. Any person who is convicted of a second offense shall be fined not less than $600, no more than $3,500, shall be confined in the county jail or workhouse for not less than 45 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for 2 years. Any person convicted of a third offense shall be fined not less than $1,100, no more than $10,000, shall be confined in the county jail or workhouse for not less than 120 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for not less than 6 years. Any person convicted of a fourth offense shall be guilty of a Class E felony and shall be fined not less than $3,000, no more than $15,000, and shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class E felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a fifth offense shall be guilty of a Class D felony and shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class D felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a sixth or subsequent offense shall be guilty of a Class C felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child of under 18 years of age, the person shall be fined $1,000 in addition to the fine for the DUI offense, and shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as an approximate result of the DUI offense, the person commits a Class D felony and shall be punished for vehicular assault as provided in Tennessee Code Annotated 3913-106. If the child is killed as approximate result of the DUI violation, the person commits a Class B felony and shall be punished for a vehicular homicide result involving intoxication as provided in TCA 3913-213, subsection B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessment, conditions of probation and/or monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring device, electronic monitoring with random alcohol or drug testing, global positioning monitoring service.
One of the charges here is theft of property, which is defined under Tennessee Code Annotated Section 39-14-103. This law makes it illegal to knowingly obtain or exercise control over someone else's property without consent. But if a defendant cooperates with prosecutors and testifies against a co-defendant, should that cooperation reduce the punishment?
In determining whether a conviction is the second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of the previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall also be considered in determining the number of prior offenses. For purposes of determining if the person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person is convicted of DUI as a multiple offender, a prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI as long as the person was convicted of the prior offense before committing the instant violation of DUI. A defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of a DUI offense. Unless a person convicted of violating TCA 55-10-401 is determined to be indigent, the minimum applicable fine shall be mandatory and shall not be subject to reduction or suspension. All fines are to be paid on the date sentence is imposed unless the court makes an affirmative finding that the defendant lacks the present ability to pay. The court shall then order a date certain before which payment shall be made should the defendant fail to comply with the orders of the court. The clerk shall notify the court of the failure for further proceedings. Payment of restitution to any person suffering physical injury or personal loss as a result of such offense, if the person is economically capable of making the restitution, shall be imposed as a condition of probation. Now, I am going to give you this sheet that shows that you have had this read to you in open court. I am making an affirmative finding that she lacks the present ability to pay due to the fact that she is indigent and has a public defender, as well as the fact that she is presently incarcerated. She'll need to sign that. Now, do you understand everything that's been explained to you thus far?
Yes, sir.
You still wish to plead no contest and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges.
Yes, sir.
Do you understand? Then if you'll listen as the state tells me what their evidence would be if this case went to trial. Mr. Vaughn, Mr. Willoughby, if you'll pull that microphone up, I don't know if it's working or not. Is it working? Nope. All right, come on up.
In 19814 on November 24th of last year, officers were sitting stationary at a gas station, I believe on Jackson Phelps Road here in Cheatham County, Tennessee. They observed a pickup truck pull into the gas station, pull up to the pumps. Ms. Bumpus did get out of the driver's seat. She did go inside the store. remained inside the store for about 40 minutes. Officers then approached and ran the tag of the vehicle, which came back stolen. Miss Bumpus, once she noticed the officers, they would state that she went back to the vehicle. The passenger in the vehicle, who's the co-defendant, gets out of the passenger seat, attempts to go to the driver's side, and then attempts to go in the store. He is taken into custody as well as Miss Bumpus. They are separated. Once they are separated, both are very clearly under the influence of whatever substance, probably fentanyl and a methamphetamine mix, which I'll get to in a second. They talk to Miss Bumpus. She states that the passenger does have drugs in the vehicle as well as on his person. Officers go and search him and find, I believe, 25 grams of.
The second conviction involves driving under the influence, governed by Tennessee Code Annotated Section 55-10-401. DUI penalties increase sharply with repeat offenses and can include jail time, license suspension, and fines. But if someone has already spent months in jail awaiting trial, should time served count as enough punishment?
And 17 grams of two different substances. I forget which one was crystalline and which one was suspected heroin in a sock after they took him into custody. During their interaction with Ms. Bumpus, she continually makes reference that there are drugs in their car and they do belong to the co-defendant, and she would be a witness at trial if her co-defendant goes.
All right. Ms. Bumpus, do you understand that's what the state's evidence would be at trial, and that you have agreed as a part of this agreement that you're going to testify truthfully to the against any co-defendant that might be required to go to trial? Do you understand that?
Yes, sir.
And you understand that would be in compliance with what the state has said their facts are? You understand that?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
Feel like Mr. Vaughn's done a good job of representing you competently?
Yes, sir.
Mr. Vaughn, do you know of any reasons you should not enter this plea?
No.
Anything further from the state?
No.
Then Jerry K. Bumpus in docket number 19814, upon your plea to count 6 of no contest, I find you guilty of theft of property, sentence you to 6 years in Tennessee Department of Corrections that will be suspended to supervised probation. There is no restitution to be made. You are required as a condition of your probation to give truthful testimony against your co-defendant if you're called to do so. Count 7, you're found guilty of driving under the influence. First offense, sentenced to 11 months and 29 days in a county jail, sentenced to supervised probation on time served, which she has credit for time served from November of 2024 of 2025 until today. So she's more than completed the DUI sentence. And she has a $350 fine and cost, loss of her license for 1 year, and she must complete the victim impact panel. She'll still need to see the probation department. Counts 1 through 5 are dismissed.
In the end, the judge accepts the plea agreement and sentences the defendant to 6 years in the Tennessee Department of Corrections, suspended to supervised probation, along with penalties for DUI including a $350 fine and 1 year license suspension. The agreement also requires her to testify truthfully against a co-defendant, which prosecutors often rely on when building larger cases. These plea agreements are allowed under Tennessee Rule of Criminal Procedure 11, but they often raise tough questions. Did the judge strike the right balance between accountability and cooperation, or did this deal give the defendant too much leniency? What do you think, fair outcome or questionable plea deal?